I must say that thanks all for your again attending this webinar. This shows lot for us. It means lot for us because just we are back with again webinar continuity after a small break. But of course, something has happened in this break. I have come out with a book, Recent Judgments on Insolvency Law, with Corporate Law Advisor. It covers all the laws topic-wise in NCLT, NCLT, Supreme Court for topic-wise. You get decided cases, but this is topic-wise segregation with the small summary in the index also and later on detailed decision. Friends, this is the book. I know it's too heavy, but this is something very different is there. That's why we have compiled this all summary, topic-wise, very interesting. And on the similar line, now we are starting this way that topic-wise, the provision, decided cases, and of course, all IPs and everyone need to know all disciplinary orders during what happened and recently happened, which is very crucial for us, how to handle our process. So that will be always part of our presentation. Thanks a lot, friends. You are back with us and we are back with the same band. With this way, the first topic today is decoding of IBC, voting in CoC, including judgments and disciplinary orders. Friends, this voting in CoC is always an issue. And our panelist, Mr. Aniruth, has joined. Welcome, Aniruth. Thanks for your time. I have to introduce.
Thank you, madam. Thank you, madam.
Thanks. I know you may be busy, Aniruth. So since it was already 8 minutes late, I thought we'll start because we want to close it also right time.
Yes, madam.
Okay. To introduce Aniruth shortly, we know each other since years, and he's a practicing lawyer. He is a proprietor of Lex Legal Corporate Law Advocates. He is a law graduate from Bangalore, practicing from Mumbai, and practicing in IBC, company law, and other laws, and practicing in original side in NCLT, Bombay High Court, and other courts. He is also practicing in SURFACE, labor law, and other things, empaneled with various corporates, assisting so many IPs, representing so many IPs, also representing corporates and various other fields. And it's since years he's practicing. Thanks a lot, Aniruth, for your
Thanks
time.
for the kind introduction. Thanks for the kind.
So today's first topic, we have taken voting on CoC, including judgments, because friends, voting is very crucial because any decision or any application we file, we need that support. That was why we are filing CoC approved and all that. So if there is any issue or voting resolution is not proper, there is a issue in the situation, and many times our decision or action get challenged for certain administrative mistake. That should not happen. So we have selected this topic. Our presenter today is Ms. Philby Philip. She is also involved in compliance with Mehta and Mehta Insolvency and Restructuring LLP. Beautiful presentation she has done, very crisp and interesting. Thanks, Philby. With us, our other panelists, our partner Mehta and Mehta Insolvency Restructuring LLP, CA Hemendra Paliwal ji. Welcome, Paliwal ji. He is also chartered accountant and IP.
Thanks, ma'am.
With this, I'll request Mr. Aniruth to say a few words on the topic, and then Ms. Philby can start the presentation. Over to Aniruth. Thank you.
So voting in CoC is a very, very crucial component for passing any resolutions and for dealing with all crucial aspects of CoC. More often than not, the deliberation of agenda in the CoC occupies a very vital role in CIRP, and it is the CoC minutes and the CoC meetings which drive the entire CIRP resolution. So the CoC voting should be steered in such a way that the intent and motive of the CoC's members come out very clearly. Sometimes the CoC's members wanted to achieve certain resolution, whether for or against, but unfortunately that does not get reflected in the CoC voting patterns. So I would, in fact, call upon all members of the IP fraternity to ensure that the CoC voting is recorded, though the regulation permits us to vote by show of hands or by sound or by merely saying yes or no. My recommendation will be to have it uh, to have the voting sheet signed if it is a physical voting, so that the yes or no of the members who participate in the voting is clearly marked and then could be minutized and could be represented before the legal forums if called upon. And if it is an e-voting, then of course there are e-voting platforms where these decisions are, clearly recorded. But physical voting, the members should take care. Then we can get on with the topic, and as and when there are certain issues, we will discuss.
Thanks, Mr. Aniruth. Yeah,
Thank
Mr. Paliwalji, you would like to say a few words, or we can start presentation?
We can start. I will, on the presentation, I will just keep adding my inputs.
Thank you. Yeah, please start.
So, good evening, everyone. Firstly, I would like to thank ma'am for giving me this opportunity to present and, navigate through this topic. So now, without further ado, let's go to the PPT. So now, here the first slide, the basic question. So what is voting under the IBC and why does it matter? So voting under the IBC, it refers to a process by which creditors make the decisions regarding the resolution of an insolvent company or an individual. So it's a decision-making power given to the creditors as per their financial stake owned to the creditors by the city. Now, it is a voting power in the CoC, which is the voting power in the CoC is as per the proportionate to the debt owed to the each creditor. For example, if a creditor is owed 20% of the total debt, so they have 20% of the voting power. Now, voting ensures the right of the creditor are protected. Each creditor has a voice proportional to their financial stake in the company. This way, a resolution plan that aligns with the majority's interest is adopted. Now, IBC involves multiple creditors, each with a financial stake in the outcome of the insolvency proceedings. Now, voting allows these creditors to collectively decide on the best course of action. Without voting, it will be difficult to reach a consensus among all parties involved. Now, it also helps in transparency and fairness. Also, it is an established, clear voting mechanism where the IBC aims to resolve the insolvency case quickly. And finally, this outcome of the voting process determines the future course of action for the insolvent company, whether it will be restructured, sold, or liquidated. So now, who can vote under the IBC? So who has got the power? So yes, it's the Committee of Creditors. Now the next question is, who are this committee? Who is this Committee of Creditors? Which is very well explained in section 21. So in section 21, what it says? So it says the IRP after RP after collation of all the claims received against the corporate debtor and determination of the financial position of the corporate debtor, the RP constitute a Committee of Creditors. Now, it shall comprise of all financial creditors of the corporate debtor. Now, if a financial creditor is a related party of the corporate debtor, then it shall not have any right of representation, participation, or voting in a meeting of the Committee of Creditors. Now, suppose a person is both a financial creditor and an operational creditor. Then they will be considered a financial creditor only for an amount of financial debt owed by the city. They will be included in the committee of creditors and will have voting powers based on the amount of financial debt owed to them. Now, for example, I am the financial creditor as well as operational creditor with a total claim of rupees 10, and out of which financial claim is rupees 2 and operational claim is rupees 8, then my voting power would be based on the financial claim of rupees 2 only. Now, what if an operational creditor has assigned or legally transferred any operational debt to a financial creditor? So in that case also, the transferee shall be considered as an operational creditor to the extent of such assignment. You can increase their total claim. You cannot increase their voting percentage. So now the next question is, what if there is no financial creditors? So if there is no financial creditors, then all the and if the financial creditors are related parties, then the committee shall be set up in accordance with the regulation 16 of the CRP regulations. Now, what does regulation 16 says? Now, committee can be formed under regulation which shall consist of members of operational creditors. Now, which operational creditors? Now, 18 largest operational creditors by value, provided that if the number of operational creditor is less than 18, the committee shall include all such operational creditors, plus one representative elected by all the workmen other than those workmen included under this 18. Then one more representative elected by all employees other than those employees which is elected in the 18 operation creditors. Now, for example, in a corporate debtor, there are 40 operational creditors, including the statutory bodies, employees, workmen, and others. Out of which 40, the 18 highest operational creditors will be forming part of the committee of creditors. Along with that, there will be a representative for all the workmen, excluding if someone is included in that 18, there will be a representative for the workmen. Along with that, there will be a representative for an employee. So in short, if the CoC is made of operational creditors, then workmen and employees will always be part of the committee irrespective of their claim amount. Now, the question is, what if there are home buyers or deposit holders involved? Then an authorized representative comes into picture. Now, who is an authorized representative? So that is also explained in section 25A. So an authorized representative in general definition, though it is not defined in IBC, is a person appointed to represent a group of creditors, particularly when there is a large number of creditors with similar claims, such as home buyers depositors. Now, a financial creditor other than home buyers can also appoint an AR. However, an AR is to be appointed mandatorily under the class of creditors like home buyers and deposit holders. Now, authorized representative is appointed with the approval of AA to represent specific classes of creditors such as home buyers, deposit holders. Now, their role is to liaison between the creditors they represent and the CoC. They have to attend the CoC meetings, participate in the discussions, and vote on behalf of the creditors they represent. Now, they also have to take voting instructions from those home buyers or deposit holders they represent and cast votes in the CoC based on those on these instructions. Now, it is their right to receive. It is AR's right to receive all information and documents related to the insolvency resolution process. It is their duty to act in the best interest of the creditors they represent. Now here I have here I have provided the sections and regulations majorly covering the voting of the committee. It's the exact verbatim and regulations that, and I want the participants to have this opportunity to read this along with me so that you word to word understand what exactly the code or the regulation wants to say. Now here in section 5, subsection 28, it defines about the voting share and voting, sorry. So here it defines about the voting share. So it means the share of the voting rights of a single creditor in the committee of creditors, which is based on the proportion of financial debt owed to such financial creditor in relation to the financial debt owed by the corporate debtor. The same way what we defined in what we saw in section 21. Now we are coming to CRP regulations, where regulation 25 says about voting by the committee. So here it says 28, whatever items in the future slide, we will see what are the items which is covered under section 28. So here it says whatever items or matters are mentioned in section 28 shall be considered in the meetings of the committee. So second thing, any action other than those will requiring approval may be considered in the meetings of the committee. Now here the third and fourth point, sub-regulation is important, which clearly says the resolution, the RP shall take a vote of the members of the committee present in the meeting on any item listed for voting after discussion on the same. And at the conclusion of the vote at the meeting, the RP shall announce the decision taken on items along with the name of members of the committee who voted for, against, or abstained from voting. So though we are going to give them an opportunity through e-voting, but as per the regulation, it says the RP has to take the vote for those items which is listed under the voting and ask the committee members whether they want to vote for, against, or abstain, and same has to be recorded. Now, if we go,
even if there is e-voting provided, RP has to do this.
ma'am, that's what the regulation says. You need to ask, because what the code wants is to resolve the issues or take the voting at the earliest at the meeting itself. And suppose during the meeting, if the members are not able to vote or someone is not present, then you give the opportunity for re-voting. And in most of the cases, yes, ma'am.
So you
No,
can say,
madam, this, yes.
Yeah, Aniruth.
Yeah, I'll take the question, madam. So,
Yeah.
the query is, though the e-voting is there, your query is, should an RP announce the decision taken? So this decision taken, madam, is announced by way of the minutes which are then circulated, because each and every resolution is then said to be passed or rejected as per the voting percentage required. For instance, if it is a resolution plan, the voting percentage required is 66%. And as per the e-voting results, then the RP should say that whether this decision taken is passed or rejected. And for 12A, it is 90%, as we all know. And for certain other routine decisions, it is 51%. So as per the e-voting results or physical voting results, RP is then required to say whether each and every resolution is to be considered as passed or rejected.
So we can say that, if I can say for the type regulation 25(4), that if there is a physical meeting and everyone is present, RP has to put it before the members and then announce that yes or no, and then say this members voted in favor and this against this, or who has abstained. And accordingly, it will be minutized also. In case of, so he has to, during that meeting also has to announce. But suppose there is someone is absent and it cannot be decided, in that case, there will be e-voting. So in that case, since there is e-voting, resolution is not yet passed, because people who are not present also given opportunity. So voting is not concluded. So I think for that reason, RP should not declare or do this process. Further, also, so e-voting it will not require, but physical meeting where everyone is present, where in that case e-meeting will not happen, there he has to take a discussion, ask everyone, and finalize the whether resolution passed or not with the name of members, because that will decide the voting percentage, who has voted favor and abstain. Am I correct? This is the way we can see that, Aniruth?
Yes, after conclusion of the e-voting conference, madam.
Okay, thank you. Yeah.
So now, yeah. So now we will go to subregulation 5. Now here the RP shall circulate the minutes of the meeting by electronic means to the committee and the AR, if any, within 48 hours. So that is the time period which is given to the RPs. Within 2 days, you have to circulate the minutes. Now subsection B clearly says seek a vote of members who did not vote at the meeting on the matters listed for voting. So there are chances during the voting the member was present, but he didn't vote. So in that case, seek a vote of members who did not vote at the meeting on the matters listed for voting by electronic voting system in accordance with Regulation 26. So Regulation 26 says voting by electronic means. Now, where the voting shall be kept open from the circulation of the minutes for such time as decided by the committee, which shall not be less than 24 hours and shall not exceed 7 days. So this is a recent amendment made by the IBBI, provided that on a request for extension made by a creditor, the voting window shall be extended in increments of 24 hours a period. So there are chances most of the CoC members, especially the banks, they ask for like 15-20 days. So here it clearly says the voting window shall be extended in increments of 24 hours period. Further, there is one more provision where it says, provided further that the resolution professional shall not extend the voting window where the matters listed for voting have already received the requisite majority vote and one extension has been given after the receipt of the requisite majority vote. The panelists, do you have any views on
like
this
Aniruth,
or any
comment
practical difficulties?
Provided further in that two proviso.
Madam, once a voting window is closed, then it cannot be extended. If the voting window is not closed, then it can be extended.
Right.
So that is a subtlety every RP should keep in mind. And more so, madam, these issues will arise whenever there are class of creditors involved. Because like for instance, if wherever there are debenture holders or home buyers, they are represented by an authorized representative. An authorized representative will act on the instructions of the class of creditors. And he will have an internal voting mechanism between them because 51% of the class of creditors instructions will bind the rest 49%. So the authorized representative is bound by 51% of those who instruct him in a class of creditors. So perhaps, madam, for certain decisions to obtain that instructions so crystal clear will be a task in itself by the authorized representative, who is normally a resolution professional only. So in that case, they may request for an extension.
So, but in this case, it is like that, if voting window open, it will be open not less than 24, not exceeding. After 7 days, if someone is requesting, then you can extend, but that also for 24 hours. That is so, if there is second request, you can do second time 24 hours. If so, only you can extend, but there is no limit for extension. How many times you can do extension? That is very important point to be noted.
Except that, madam, if at all the matters which are listed for vote, if that receives the majority vote.
Yeah, required majority. Then it is fast.
Then the limitation is there. Then the limitation is only one occasion it can be done.
Sorry, what?
So let me read out that proviso, madam. This says, provided further that the RP shall not extend the voting window where the matters listed for voting have already received the requisite majority vote and one extension has been given after the receipt of requisite majority vote.
Yeah.
So which says that there is a space for giving one extension.
Even after requisite majority, give one extension, but after that, no extension.
No extension.
So even though resolution is passed with requisite majority, if someone requests for one extension, we have to give that. That is
Yes.
the point.
There are enabling powers to give one extension.
One extra. And technically, what it says ki if we have 51% majority and we already achieved the 51% majority, we can give a 24-hour extension to on any request by a non-voting creator. Or in case of 66%, we already achieved a 66%, and somebody is still requesting, sir, I want to vote, give me for further extension of 24 hours. So we can give a single extension to such creators, class of creators. Okay, we give additional 24 hours to vote. If we don't vote after even 24 hours and requisite majority is there, then we can close the voting lines.
So here my question will be whether RP is, but if after requisite majority request is received, RP is compelled to give extension or has option to give extension?
Compelled. There is a minimum 24 hours has been given. Okay.
Yeah.
Right. 124 hours request.
Yeah.
I am in agreement, but I am in agreement with Mr.
Yes, Mr. Kamlesh has asked, so if I understand these matters, the non-residents can only will get an opportunity to vote electronically. No, Mr. Kamlesh, it is if your meeting is physically conducted and everyone is present, you can vote there physically. But if even a single member is not present of CoC, then you have to compulsorily conduct e-voting. And whether he is in India, resident, non-resident, whatever, that is not the matter. So e-voting is open to even resident CoC members. I hope the matter is clear.
Even when you attend a online CoC meetings sitting at some other countries, you can officially vote on even though you are physically not in India, you can do a voting in a meeting itself.
Yeah. Like Companies Act in IBC also people attend from overseas. I have my overseas creators from different countries attend. Oh, thank you, Mr. Company. Yeah. Go ahead.
So then moving to the last sub-regulation. So when the authorized representative shall circulate the minutes of the meeting receipt under sub-regulation 5 to the creditors in a class and announce the voting window at least 24 hours before the window opens for voting instructions and keep the voting window open for at least 12 hours. So when the home buyers are in picture, then there is a different voting portal which is open for the home buyers so that they can give instructions to the AR so that AR can vote to the main voting portal which the RP has started.
Let me one question from my side here. Since in class of creators, people will keep voting. There could be possibility, first phase when he access the data, he's observed only 60% is voted. So can he keep updating his output to RP's portal? Okay, these people have been voted like this.
So no, so that we will be covering in the next regulation where it is clearly mentioned how the the voting by authorized representative has to be calculated. So this question I can answer you in the next slide.
Okay.
So here it is. So regulation 25A, voting by authorized representative. Sir, I will just cover it and then I will answer your question through this. Is that fine, sir?
Yeah, we'll do.
Yeah. So here the authorized representative shall cast his vote in respect of each financial creditor or on behalf of all financial creditors he represents in accordance with the provision of subsection 3 or subsection 3A of section 25A. So now our question is, what is section 25A? And subsection 3 and 3A says. So now here it says about the rights and duties of AR of financial creditors. So here In subsection 3, it clearly says the AR shall not act against the interest of FCs he represents and shall always act in accordance with their prior instructions. So without their prior instructions, the RP cannot vote. Now, provided that if the AR represents several financial creditors, then he shall cast his vote in respect of each financial creditor in accordance with instructions received from each financial creditor to the extent of his voting share. Now, provided further, second proviso, if any financial creditor does not give prior instructions through physical or electronic means, the AR shall abstain from voting on behalf of such creditor. Now here, as I cleared or explained before, now ARs can be appointed for home buyers as well as other financial creditors who wants to bring AR into picture. Now, suppose if it's a consortium of agreement where 3-4 banks are involved. So each one have their own ratio. Suppose one is having 50, 20, 30, 10, whatever it is. So the AR has to get instruction from each one, and that voting has to be done. Of course, that time period which is allocated as per the AR has to be provided. Like if AR has given 24 hours, within that 24 hours, if he receives that information, according to that information, he will cast a vote there. Now, that is an example here, how the voting has to be done. Now, 3A, subsection 3A says, notwithstanding anything to the contrary contained in subsection 3, the AR under subsection 6A of section 21. Now, what is subsection 6A of section 21? This is specifically for ARs who are the authorized representatives for home buyers and deposit holders, shall cast his vote on behalf of all the financial creditors he represents in accordance with the decision taken by a vote of more than 50% of the voting share of the FCs he represents who have cast their vote. Provided further that a vote to be cast in respect of application under section 12A, AR shall cast his vote in accordance with the provisions of subsection 3. Now, I explained you subsection 3. Now, in subsection 3A, what it says, suppose home buyers, if there is a resolution which 66%, 51%, whatever it is. Now, if you see in this regulation, if you see, the AR has to give this opportunity. They have to get the voting instruction from these home buyers. So here, before 24 hours, the AR has to inform the home buyers that that window will be open for you, where as per the regulation, it clearly says the minimum time which you have to give is 12 hours. Then it's up to the AR how much time you want to extend, and in consultation with the RP, how much extension he is ready to give. Like 24 hours extension or this, however, like as per subregulation 5, second provision and first provision. In that coordination, you have to give the home buyers also the time, but the minimum time which you have to give is 12 hours. And on that basis, if you get 50% of the vote to that decision, then you have to cast a vote according to that. Here there is one more catch which I feel. Here it says who have cast their vote. So here the decision of the financial creditors of 50% will be calculated as per who have casted their vote. Panelist, any views on that?
Can you come again, last point?
So basically, according to me, that AR has to vote once he received the instruction. He has to inform to his members whom he represents, give 12 hours to cast their vote, whether yes or no on the business he asked for voting.
The voting item.
If he get requisite 50% or more than 50% or whatever it is, then only this AR can cast his vote. But if he fails to get that vote, he should abstain from voting. Now the situation is that what will be telling that in 3A what it says, in accordance with the decision taken by vote of more than 50% of voting share of finance secretary. He was telling that even the members who are represented by AR, 50% of the voting members who has voted, we have to calculate. That is the question, Aniruth.
Yeah.
What is your view that 50%? Yeah.
So
In
here
fact,
it
madam,
says-
PAN card clubs case, madam, it's a corporate debtor PAN card clubs. That is a test case to explain how an AR should work or should not work, etc. In fact, the resolution has successfully gone through before NCLT Mumbai, and I believe it is under challenge before NCLAT. I have not followed up after that. I had a chance to appear on behalf of the evaluation uh, professional who assist the AR in evaluation of the resolution plans before NCLT. This was a case where there were lakhs of depositors and they had an AR. So it was really a challenge for the AR to receive instructions from that class of creditors and to act in accordance with the majority of such instructions.
That's what I'm saying. Ki AR has a challenge when he is representing a many people. If it is 5, 10, 10, 12 people is okay. But once you have quantum of 10,000, 1 lakh, 10,000, 20,000, then within 12 hours communicating with them and getting a response will become a challenge for AR to achieve a 50% of a voting from all people. Because we know people don't respond very fast, especially when the home buyers are there. There are some other categories are there.
So for that reason, Aniruth will be checking whether we can count the 50% voting, means 50% positive voting of the members who voted for that matter.
Yes. So here
Absolutely.
it mentions. Yeah.
Aniruth?
Absolutely, madam. Absolutely, madam.
So we have to count that suppose that AR is representing 1,000 members of that class and only 100 voted, of which 80 voted in favor, 20 negative. Still, he can go ahead. He got the instruction to pass, give vote in favor, so he will vote in favor. Am I correct? This is the situation, right?
This is the situation. This is the situation.
Yeah.
In fact, madam, this is supported by NCLT Mumbai judgment also. Reason being that there were lakhs of depositors, and these lakhs of depositors could not vote. Majority of them could not participate in the voting mechanism of giving instructions to the AR. So the AR went with the majority of whomsoever have voted.
Yeah. Right.
In fact, madam, that NCLT Mumbai judgment also calls upon IBBI to look into these aspects. However, they have approved that resolution. But this is some area, madam, where there are lakhs, then there should be some mechanism evolved to capture the intent of each and every person.
Right. Okay. Thank you. Yeah. Thank you.
Thank you. Thank you so much. So now this is about for all other resolutions, you can go with this 50%, but the regulation clearly says when it comes to section 12A, when if application of under section 12A, that is withdrawal of the application, that is to withdraw the CRP process. In that case, you have to calculate the votes as per subsection 3. Suppose there are, as ma'am said, if there are 1,000 home buyers, each vote matters. Each member will have to vote and it has to round off to 90%. And only then that application will can be withdrawn, only if 90%. For rest all resolution, that 50% who have casted their vote will be the way of calculation. But when it comes to section 12A, that is if you have to withdraw the application, then each and every financial creditor will have to assent the vote and give a 90%, and only then that application can be withdrawn. So now moving to the next slide. So voting through electronic means. So here the RP, as I said, the RP shall provide each member of the committee the means to exercise his vote by through electronic means or electronic voting system. Here they have mentioned what is voting by electronic means, whether it should be secured without any unauthorized access or misuse, any proper way. And at the end, the voting period, the voting portal shall forthwith be blocked. At the conclusion of the vote held under this regulation, the RP shall announce and make a written record of the summary of the decision taken on a relevant agenda item, along with the names of the members who have voted for or against or abstained from the voting. And RP shall circulate a copy of the record made under the subregulation to all the participants by electronic means within 24 hours of the conclusion of the meeting.
This point
So-
number 4, we were discussing that noting, right?
Right.
Absolutely, madam. This when read with that extension, madam, that extension of 24 hours could only be given if the request is made before the conclusion of the voting period. This is what I was saying in that.
Okay, thanks.
So I have here a question to the panelists. So there are times when I have seen a practice of postal ballot, like a paper, like postal ballot in Word file, rather than doing e-voting, just to, to incur less cost.
Yeah.
Yeah, to cut the cost, they use postal ballot, like you send in a Word file and they have to sign and send the paper. So will it be like voting through electronic means? Will that come under voting through electronic means? Or is it debatable? Like still there is, it can be a question.
But I believe nowadays for the IBC process, where the threshold limit is only 1 crore, whether it is practical at all to cut down the cost of e-voting portals, when now the e-voting portal is something which is widespread. Because earlier in the initial days, only there were certain platforms and certain service providers. And the cost, I believe, is also not much nowadays. So therefore, it is advisable to opt for e-voting in the absence of physical voting.
But Aniruth, what happens? Sometimes IP say we don't have fund and we have to run the show. So we will do postal voting then.
Madam, but postal voting nowadays, madam, then one can take voting by way of an email, no? Why should then they go for?
Yeah, right, email also.
Yes.
It can't be. According to me personally, I believe it can't be replacing e-voting. It's very clear. Electronic means.
Correct.
During
In that case, even mail is electronic means.
yeah.
Ma'am, it is not secured. It can be tempered.
It can be, yeah. It should be secure, right?
It should be secured. So it is not
It
secured.
is only voting.
But these are the practical challenges for RP where he face a problem where the CoC do not pay the funds and expect the service delivery. That's definitely a concern of all RPs given.
And further, this says that, madam, it should be counted in an electronic registry. If we see that expression, this says such that the voting exercised by way of electronic means gets registered and counted in an electronic registry in a centralized server with adequate cyber security.
Yeah, got it. Yeah. So it is required that electronic voting only will be there, no other way. E-voting.
Right.
Oh.
Yeah.
Thank you so much. So now we will move to the next slide. So now we have just covered the sections and regulations which was covering the voting. Now here I have just give a snippet of what are the sections and what are the minimum voting share required. So voting share required under various sections and regulations. Just to have a glimpse of it. Now section 22 and section 27 where it defines about appointment of RP or replacing the existing RP. So the minimum voting share required is 66% of the voting rights. Then section 12, which is one-time extension. That is, though it says one-time extension, the minimum time period, which as per the IBBA provided is 330 days. And in practical scenario also, we take extensions, which also requires each time 66%. Then section 12A, withdrawal application, 90% of the voting share. Now section 28, now as I said, I mentioned before, so matters mentioned under section 28, just a rough rough glance what are included in Section 28. So it involves interim finance, security interest, buyback or redemption of issue securities, giving instructions of financial institutions, maintaining corporate debtor, record any change in ownership interest, delegate its authority to any other person, any amendment to the constitutional documents, any related party transaction, further any changes in the management of the corporate debtor or its subsidiaries, transferring rights or financial debts or operational debts under material contracts. Now, the last 2 points says making changes in appointment of terms of contract of such personnel as specified by the Committee of Creditors, or make changes in the appointment or terms of contract of statutory auditors or internal auditors of the corporate debtor. So the last point, I find it very, important, because most of the time, during the process, we will see statutory auditors, we will have to first check their contracts, whether that contracts, is it running, whether they are still as per the AGM, whether they have been appointed for 5 years or 10 years. And if we want to bring some other statutory auditor into the picture, so it is always advisable to first, we have to, as per Section 28, we have to take pre-approval of the Committee of Creditors, and then only we can do any actions or take actions, or else it will be considered void. So that was about Section 28, which also requires 66%. Then Regulation 29 says about sale of any assets, that is the unencumbered assets by the RP outside the ordinary course of business, which also requires 66%. Then Section 30, that is approval or rejection, 66. And last, all other matters like which is not included or included above will require 51%. Now, this is a debatable topic, like how are the votes to be calculated? Now, there are different scenarios. Now, here I have just, put a table here, the scenario for a resolution which requires 66% voting. Now, the scenario A, B, C, the assent by the claim amount we can consider is 50. Then for the dissent is 10, abstained is 10, not voted is 10. Same goes with B, C. So C, of course, it's clear picture. It is more than 66%. But what about A and B? So how it has to be calculated? What will be the denominator? Is it assent divided by assent plus dissent plus abstain plus not voted, or the total claim? Or it should be just who casted the vote? Or should it be just assent or dissent in the denominator to be considered, and the people or the creditors who have abstained and not voted should not be included? So this, I would like the panelists to give us their views and opinions on what exactly or how it has to be calculated as per the Supreme Court judgment also I have mentioned here. So what is the appropriate way, or what is the proper calculation, or how it has to be done to arrive at that 66%?
Before going to this calculation, hear me about this
I think
judgment.
Mr. Aniruth is.
No, let Mr. Paliwal continue. I will join. I'll add to it.
Okay.
Let I just brief you about this Supreme Court case where the case either versus Indian Overseas Bank. This is a classic case of voting only, and this has been took place somewhere in 2017. At that point of time, the 75% was a criteria for passing a resolution plan. And when the voting took place on a final meeting where the final voting took place, unfortunately, two bankers, Indian Overseas Bank and Central Bank of India, IOB had a 15.15 percentage share in the voting, and Central Bank of India had a 11.82%. These both put together become a 26.97, which was a more than a 25%. So technically, at that point of time, this resolution plan cannot be passed because the resolution applicant, resolution plan could not be voted more than 75%. There was a one banker, Bank of Maharashtra, which has a 6.36, but he remained neutral. He not voted, he abstained. This RP in principle, he said that this has not been passed, and he put an application to adjudicating authority in NCLT. NCLT somehow approved it. Since the spirit of law is that it should be the decision should be given to the corporate debtor. Anyway, finally went to Supreme Court. And by the time it went to Supreme Court, there was a change in law in June 2018, where the 75% becomes 66. And technically, since it becomes 66%, when the case went to Supreme Court, even the one more debate has come, so now the limit, which was earlier 75%, now it is 66%. And since now we have more than a 66% assent, excluding Bank of Maharashtra, because the Bank of Maharashtra is only 6%. So they had heavily argued that this plan should be passed. Even the applicant made an application to the Supreme Court. It is very lengthy judgment, but finally Supreme Court says that when the CoC pass this plan or disapprove the plan, that point of time the regulation was very clear. It was a 75% required majority to pass the resolution plan. Since at that point of time that law was in force, now even the law has been changes, yes, substituted with the 75 to 66%. But the decision of CoC at that point of time was very clear. And from that perspective, we can't say today it is 66%, it should be approved. So somehow the Supreme Court rejected the application by resolution applicant and CD as well, asking this plan cannot be approved because at point of the CoC, the 75% people have not voted in favor of the plan. That is the crux of this case, where the Supreme Court clearly laid down on a CoC meeting, it should be clearly people who voted should have a clear majority. That point of time 75%, now it is 66%. So to large extent, people who, from my perspective, people who are abstained, who are not voted, so they've foregone their right, and people who are not voted, it's their choice, they have not voted. To large extent, my belief is that people who voted should be a denominator, and accordingly percentage should be calculated. But I don't have a legal precedence for it, so Aniruth will be able to tell us.
Thank you, Paliwal. Very detailed analysis you have done. Yeah, Aniruth,
Yes,
please.
yes. Thank you, Paliwal. I'll only add to it. I'll continue from where he has left off. In fact, according to me, the case Shashidharan judgment puts an end to the confusion, at least as far as how the voting on the resolutions for a resolution plan must be addressed or how it should be concerned. So, according to Honorable Supreme Court, there should be a positive vote of 66%. That is, positive majority vote should be computed for computing the resolution. For instance, if there are 100 people and out of this 100 people, 66 have voted in favor of the resolution plan and the rest have dissented, yes, that resolution can be considered as passed. Supposing only 50 have exercised their right to vote and 50 have abstained, and out of the 50, the entire 50 have voted in favor of the resolution plan, then what should be done in that scenario? Because if we then eliminate that 50 who have abstained, then it is a 100% vote. But what Supreme Court says is that cannot be eliminated. The positive vote should be seen. Positive vote means the voting in favor, which is exercised, must be to the tune of 66.66, without which that resolution cannot be considered as passed. At least in the facts of that case, they were dealing with a resolution concerning passing of a resolution plan. So that ratio rationale is still valid and that will still subsist, at least as far as the resolution concerning a resolution plan is concerned.
So we can say that 66% of people positive vote of the 66% of the people entitled to vote, not 66% of the voting actually happened.
Correct. That is so well put by you, madam.
Okay. Okay. Yeah, Surbhi. So it will
Yes.
be like whether they vote or not vote, entitled to
It
vote,
doesn't matter.
you have
So
to get
we
66%.
have to get 66%.
At
So
least
even
for resolution plan, that is clear.
yes. So for resolution, so of course that for rest of the matters also we would try to implement the same practice of calculation. And so in that scenario, A and B doesn't get in this scenario, the A and B doesn't get approved. Only the scenario C gets approved. And adding to that, I think IBBI has been very clear when it comes to AR. They specifically said 50% of who have casted their vote. In rest all regulations, they have said 66% of the total voting of the voting rights. So where we have to take in total of the total CoC members, we need to have that proper 66 assent or 51 assent, whatever it is, and then we have to calculate. So thank you, panelists. So now we move to the last the last slide, this slide towards the last slide before the legal NCLT cases we hear. So these are some of the few points, the practical difficulties found during the voting. So this during the PPT, when we came across and when we were discussing, we already discussed few of these points, but just running through it. So one is the diverse inverse, like creditors may have conflict of interest, making it challenging to achieve or come to a one point on the resolution plans. Then the participation challenge, just like Paliwal said, like some creditors may be unavailable or unwilling to participate in the CoC meetings, leading to a low attendance and potential issues with quorum requirements. Now, there is another problem like technological barriers, like where the creditors may have access to necessary technology or may not have necessary technological background or understand how to use it effectively. Then the timeliness of the decisions. The need for timely decisions is critical, but the voting process can be prolonged due to disputes taking approval from the higher authorities. In most of the cases we see, like when it involves banks, they always have to go to their higher authorities. They ask extensions. So that is one of the difficulties which we face, and the uncertainty of the outcomes. We never know what outcome or of the votes will be, and it is unpredictable. And creditors may be hesitant to commit to plans that they may believe may not be in their best interest. So now, so this was all about the voting, the practical difficulties, what are the rules and regulations which we have to, and the process which is involved in the voting. Now, if you see, if I give you a gist of how the voting or how it starts and it ends. First, we have to give details about the voting in the notice. The notice goes during the meeting. If as an RP, you have to seek their votes, whoever is present. And then if they don't vote or if the members are absent, you have to give them an opportunity through e-voting, that is through electronic means. Then within that time period, you have to give, the minutes have to be circulated. After the minutes are circulated, you have to start the e-voting. The minimum is 24 hours. The maximum is 7 days. If they ask for extension, you have to do an increment of 24 hours. And then within once the voting gets blocked at the after the end time, within 24 hours, the RP has to issue or circulate the result to all the participants. So this was a complete small gist to what we have discussed till now. Now we will finally go to the decided cases. So this is a very interesting case. Yes, ma'am.
Now we have to increase the speed.
Yes, ma'am. Yeah. So now I will just give a gist. Vijay Sani versus Sri Devendra Singh. Here it's an NCLAT order. So the proposal under Section 12A submitted by the promoter or director had been voted by financial creditors in class, giving 40.15%, where sorry. So in the financial creditors in a class, so there were three bifurcation, which I can explain here. So voting in financial creditors in class, there was yes 40%, no, there was 29.2%, and abstain, it was 11.8. Then there were two more financial creditors. For yes, it was 12.42, and the third financial creditor dissented the matter. Now here, the RP opined that the total votes in the favor of plan is only 52. If you can see, the total is 52, which is less than the requisite 90% of the voting share of the CC. Now, the AA, the adjudicating authority, stated that the RP have not followed the method prescribed under Section 25A. We just covered what was Section 25A3A, the rights of AR. And the RP incorrectly assumed that since more than 50% of CoC voted in favor of Section 12A proposal, it shall be treated as 100%, given the financial creditors are to be treated as class. Now, the NCLAT, it was appealed before the NCLAT, and NCLAT stated that voting under Section 25A, subsection 3A, the AR of financial creditors must cast votes based on more than 50% of the voting shares in favor. But this is subject to provisions that sets a different standard for Section 12A. So as I mentioned before, there was a proviso for subsection 3A where it clearly mentioned when it comes to withdrawal application 12A, then it has to be per financial, each financial creditor has to give an assent which should amount to a 90%. So that 50% calculation doesn't come into picture here, and RP was correct here. But in NCLT stated it was an incorrect calculation. And it also says application of Section 12A proposal which allows for the withdrawal of CRP, 90% of the voting shares of financial creditors, including those in class, must be in favor of the proposal to pass. And accordingly, as per the conclusion, the Honorable NCLAT concludes that the proposal under Section 12A have not been approved because it has just got 52%, and the order dated by the NCLT have been set aside, reviving the CRP of the corporated. Panelist, any comments on that?
No, this point has been discussed
Yes.
earlier as well. 90% is required. So
Yes.
what should be an NCLAT judgment in line with that?
Yeah.
Yes. So now moving to the next, where it's again an NCLAT case where the appellant, that is one of the operational creditor, stated appealed against the order of the NCLT, where the appeal was filed before because the appellant, that is the operational creditor, was aggrieved by the tribunal decision to allow the withdrawal of the CRP initiated against the corporate debtor. Now, the withdrawal application was based on the resolution passed by the Committee of Creditors, which approved a settlement offer by the corporate debtor. Now, the applicant contended that the withdrawal was approved without obtaining its consent, which was required as it had initiated the CRP. So this was someone who initiated the CRP, but the CoC members have approved the withdrawal application. The appellant also argued that the order was passed without proper recording objections, violating the principles of natural justice. Now, the decisions of the appellate tribunal. Now, it says limited jurisdiction of the adjudicating authority. The tribunal emphasized that the NCLT's jurisdiction under Section 12A of IBC is limited. If the CoC with more than 90% voting share approves the withdrawal of CRP, the NCLT cannot reject the application. Commercial wisdom, the tribunal referred to Supreme Court decision which of Valal RCK versus Siva Industries and Holding, which stated that the tribunal should not interfere with the CoC's commercial wisdom. Second thing, the principles of natural justice. The tribunal found no violation of the principles of natural justice because the CoC had voted or given 90% as per the proper calculation. All the CoCs gave a 90% voting, and accordingly the withdrawal application was made. So the contention by the applicant was invalid. And the legal precedents, the tribunal cited the Supreme Court's ruling in K.N. Rajkumar versus the Nagarjun, which upheld the right of a company director to seek withdrawal of CRP if the debts are settled. Now, disposition, the appeal was dismissed and the NCLT's order allowing the withdrawal of CRP was affirmed. The application stay was also closed. So here basically it's about they talking about whatever the CoC has decided, their wisdom should not be, the commercial wisdom should not be questioned. And even the AA have a very limited jurisdiction where they have received the voting power. If they have received the voting as per the regulation, then they have to go by that. Now, moving to the third case, that is Narendra Zindal versus HDFC Bank. Here in this case, the application was filed by the promoter. The promoter says one of the CoC member, that is HDFC, didn't approve approve for the withdrawal. So they were asking the NCLT to intervene and ask HDFC to vote. So here the financial creditors were three who were in consortium. So there is SBI with 56%, ICICI 23%, and HDFC 19%. Here HDFC objected on the ground that the resolution for withdrawal of CRP has not achieved the required 90% because the same was put for voting by the RP because they wanted to withdraw the application. And it stated the HDFC didn't approve. Now, the issue and applicant's argument was, the applicant argued that according to the RBI guidelines, particularly to the Master Circular on Income Recognition and Asset Classification and Provisioning, if a decision agreed upon by 75%, so in SBI, if you see what their contention was, if SBI, ICICI approved, so they got almost more than 55%. So its contention was, if they receive 75% of the creditors by value and 60 by number in joint lenders forum, they claim they should hold apply to the CoC's decision making also. Now, the issues placed before AA was whether the tribunal can direct HDFC Bank, a member of consortium, to approve the withdrawal application, or whether the lead bank can approve the withdrawal on behalf of another bank, even if the bank does not give a consent or reject. Now, it was very clear from the decision that the tribunal emphasized that the decision made by HDFC Bank as a member of the CoC is a part of commercial wisdom, and they cannot question or they cannot force them to follow the RBI guidelines. And as per section 238, it clearly mentions that IBC laws will be overriding or will have an overriding effect over any other laws. So the application was dismissed, holding that it cannot entertain the request to direct the HDFC Bank to approve the withdrawal application as per the RBI guidelines, which they were referring, as mandatory 90% voting has to be provided under section 12A, because this we again refer to how the voting process has to be, and we require, no matter what, how it is consortium, AR, whether it's home buyers or anything, we need 90% assent from all the members.
So this is an interesting case which Philby has just narrated, because this is a case where normally what we see in the commercial arrangement, whenever there is a consortium of lenders, the lenders will have a lead bank and they enter into a consortium agreement where they agree that the lead bank will take decisions for them, because it is not possible for each and every decision to be taken by all the members of a consortium in unison. And that is how the joint lenders meeting is also held. In a joint lenders meeting, whenever a decision is taken with 75% of the creditors, as per the RBI guidelines, it is considered to be passed. Or in fact, 75% of the value of the creditors and 60% of the members. Then it doesn't require the balance 25% of the members' consent. Now, borrowing the same logic, here the consortium of bankers wanted to apply the same in an IBC process here in the context of 12A application. Many a times I have seen that even for a Section 7 proceeding, which is filed by a banker against a corporate debtor, there may be other financial creditors who may not approve of the Section 7 proceeding because their interests are intertwined with the well-being of the corporate debtor. So other members may intervene and may tell the court, see, I am the lead banker. If at all I have to initiate any legal proceeding, it is only by my consent the legal proceeding can be initiated. Even in such a scenarios, tribunals have held that both are very different, though they are contractually bound by way of this consortium agreements, lead bank agreements, that will not have any bearing on the provisions of the IBC. So this is an important judgment in that sense that a lead bankers agreement or consortium agreement in that sense is diluted when it comes to the laws and the context of IBC.
So basically, it set the principle that even though the bankers are forming consortium, it doesn't dilute their voting right or they cease to vote, their voting rights remain and they can deviate from the voting of lead bankers.
Absolutely, madam. Absolutely. So they have an independence to
Independent
exercise
to
their
vote.
vote, which they may not have in other forums and in context
Right.
of other laws and legislations.
Right. Yeah.
Yes.
Yeah.
So rightly said. So therefore, the RBI guidelines do not supersede the specific provisions of the IBC regarding the withdrawal of CIB proceedings. So this is a Supreme Court judgment.
This
Here,
last case
the
will be for this.
no, ma'am, two more cases are there.
I think we can skip this and straight
Yeah.
away disciplinary cases in a very, because 6:30 we have to close. And only 10
Yes, ma'am.
minutes left. So I'll leave it to you. Disciplinary cases, how many?
Yes, ma'am. So this case, I can give you a gist here. There were only two financial creditors. One is State Bank, and the one is the one who is the applicant, that is Powertronics Control System. So here in this case, the State Bank approved the liquidation process, but it denied or it rejected the liquidation cost, that is Section 39A, which before the company goes into liquidation, you have to approve. So being only two creditors and the State Bank of the State Department of Gujarat having the majority vote, it was having 70%, and the Powertronics Control System, the other operational creditor, was having only less than that, that is 29 point something percentage. So the RP put before the liquidation application, the same was approved by both the parties. But when it came to approving the liquidation cost, that is as per 39D, the same was not approved by the State Tax Department. So RP had placed before the NCLT for directions, and in that the NCLT guided to where so RP was instructed to send a copy of this order where the AI has directed the State Department to attend a meeting conveyed by RP and file a report. And it also said that the State Department, it voted against the, it is also instructed to send a copy of this order. And the CoC had unanimously approved, and the NCLT guided in the next hearing, the State Department should be present and to sort out the issues, what it appears. and it stated the same has to be divided. The cost have to be divided between the state tax department as well as the other operational creditor as per their claim ratio.
Will we now take disciplinary on this and in a very fast?
So now it is about the disciplinary committee, where in this the gist is about the registration of the CD as MSME without the approval of the CoC. In this case, the RP didn't take the approval of the CoC of the CD of the CD being taken as MSME. So it was informed to the CoC members after a very long stage, that is until the 18th CoC meeting, the CoC members was not informed, and the approval of the CoC members was also not taken. So the submission of the RP was for the betterment of the company, to get more resolution plans, or it was to benefit the CED. Now the analysis and the findings, it was noted that the TC stated that the registration was applied before the finalization of the audited financial statements, raising concerns about the rationale behind this decision. The DC observed a lack of evidence demonstrating any tangible benefits from the MSME. RP said it was for the benefit, but the DC didn't find any reasons or any benefits through the MSME. Consequently, it concluded that the primary motive behind the MSME registration was not to sustain the CD as a going concern, but rather for undisclosed reasons. The reasons was not disclosed here. And there was also one case where there is also one more point added. Because of MSME, the promoters were able to file resolution plans in this case. However, two resolution plans submitted was rejected by the CoC as well after multiple withdrawals. RP also failed to inform the CoC about the MSME registration for over 3 months, revealing it only when seeking approval for reissuing the expression of interest. Now, the DC concluded that the RP's action contravened the IBC code as they were undertaken without the necessary CoC approval. It distinguished this case from previous one, noting that one of the cited cases specifically addressed the need for CoC approval of MSME registration. Unlike one cited case, there was no NCLT order directing the RP to obtain MSME registration. The DC deemed the RP's decision to secure MSME registration without CoC approval as a serious procedural oversight that comprised the insolvency resolution professional, and therefore RP was found guilty. It was considered as a contravention. So it was suggested for whatever, if there is a major change, if it is a registration, so it is always better to seek approval of the CoC and at least be informed. Not at a later stage. Here it was informed at a very later stage. Second case, that is disciplinary committee. Second case, here the allegation was against Mr. Krishnan Mohan Golamudi misused the CD's asset for a personal event. So the evidence was the CD's property was booked for the event without charge, and the supporting documents for payments to third party. And the contravention was the violation of IBC and IP regulations. So basically, it was a misappropriation of the CD resources, lack of transparency, and failure to maintain a proper records. So the RP had in defense stated that it was its bride's family who organized the wedding, and RP had no involvement in the booking and arrangements. Lack of control and external vendors, he gave his justification. However, DC findings stated that while there may not have a deliberate misuse of the CD assets, the lack of transparency and extension of complementary services raised concerns. And therefore, contravention was upheld. The DC concluded that the RP's action were in contravention of the regulation, and DC found a lack of due diligence on the part of RP in overseeing the event arrangements. So this is again the same thing, and he was charged with a penalty of 1 lakh. Now, this is I think the last or second last disciplinary committee points. So here the IBBI had sent a shock cause notice to an IP alleging the contravention of the rules and regulations. So here the key issue was that one of the resolution applicant was found to be connected to the holding company of the corporate debtor, making it ineligible under Section 29A. Now, what was the submission of IP? IP argued that the provision of IBC do not bar promoters or related parties if it fulfills Section 29A. That is, if it does not disqualify under Section 29A, then they can file a resolution application, a resolution plan. IP also submitted that since the CD accounts were not classified as non-performing assets, the promoters should not be precluded from being the resolution applicants. Now, the findings was the DC noted that the IP failed to explain and clarify the connection between the RA and the CD holding company before the AA. The DC observed that as the RP had a duty to conduct thorough due diligence and present accurate and complete information to the AA. However, DC relied on the Enclans decision in the Vishram Narayan Panchor cases, which held that the mere fact that a person submitting a plan was a promoter or director does not make them ineligible unless any specific disqualification under Section 29A are attracted. Since in the present case, none of the clause, that is from A to G of Section 29A, were attracted on the applicant, the DC did not uphold the contravention and the show cause notice was disposed. So here the case is very interesting because here it was a promoter and still he could submit a resolution plan because he was not disqualified as per Section 29A. Then this is the last disciplinary committee. Here, the IP failed to make an application under the PUFE transactions, despite the forensic audit report pointing such transactions. And second case, he abruptly terminated an e-voting process for the 10 CoC meeting on an agenda of IP's appointment as liquidator. Now, the submission made by IP was the regarding avoidance transaction. IP submitted it did not accept the CoC members did not accept the forensic audit report, and he proposed further audits, but they were rejected by the CoC members. So in his justification, RP said CoC didn't accept the audit report, and when he placed or proposed another audit, they rejected. He also suggested that banks to investigate through their own statement. Now, with regards to termination of e-voting, he stated that the agenda for appointing another RP as a liquidator was in introduction, and that's why he abruptly terminated the e-voting. Now, the analysis and finding of disciplinary committee on avoidance transaction, DC held that it is the duty to file such application lies with the RP. So here, the DC is putting that duty or pressure on the RP, stating whether the CoC accepts it or not. Once you get an idea about the forensic audit report you received and you are finding any transactions which falls under the PUFE, then it is your duty to file an application to the NCLT and seek their views. RP cannot shift this responsibility. And second things regarding e-voting termination, DC held that the IP has violated the provisions of the CRP regulations because he had some malified manner or to prevent the vote from going against his own interest. And accordingly, he was suspended for a period of 18 months, and this order was circulated to all the CoC members where he was an RP or he is an RP. And accordingly, the show cause notice was disposed of. And here, the contravention made was about the operational creditors. So if, according to his calculation, an RP, if the operational creditors aggregate dues exceed 10% of the total debt, and that notice needs to be issued only to the OCs whose individual dues exceed 10%. The IP relied on various court judgments to support his interpretation of the court provisions. The IP also challenged the NCLAT order that had made adverse observation against him in this regard. Now, the disciplinary committee found that the IP's interpretation of Section 24, subsection 3 and 4 was incorrect, as the provisions clearly indicate that the notice need to be issued to the OCs and their representatives when their aggregate dues exceeds 10% of the total debt. Now, DC noted that the IP's actions was in contravention of the code, but there were no evidence of a modified intent. And also, as per the DC order, it stated that it did not impose any penalty on the IP at this stage, as this matter was sub judice before the Supreme Court. And DC directed the board to re-examine the case after the Supreme Court's order and take further action as it deemed fit. Yes, and this was the last disciplinary committee case. I took just extra 5 minutes more from 6:30.
Yeah, Aniruth, you would like to say a few words at the end?
Yes, absolutely, madam. This is a very enlightening session for the reason that, madam, every part of a CoC meeting is extremely critical, right from its collation of claim, verification of the claim, then the constitution of the voting process, whatever committee, and who are entitled to vote and who are not entitled to vote. Because as per Section 21, certain related parties have to be kept out, which also will be carefully narrated, that proviso also, that provision also. Though the agenda was on the voting, we have elaborately dealt with every aspect of the CoC meeting, including how it has to be conducted, how voting has to be conducted, in what ways voting has been interpreted and voting should be computed. And this is definitely an enlightening session even for me. Thank you very much for the Mehta and Mehta team.
Thank you, Aniruth, for your valuable time. It was really wonderful to have with you. Thank you, Paliwal ji, for your insight and your extra comment. Thanks a lot. Thanks, Philby, for nice and timely presentation, concluding at a timely way. Thanks, everyone. Thank you. See you again.
Thank you.
Thank
Thank
you.
you so much.